The appellants and the respondents in support of the appeal came out strongly, challenging the High Court's finding on the applicability of the doctrine of the basic structure in Kenya. On the other hand, the respondents opposed to the appeal came out in equal measure in support of the findings of the High Court. Both sides of the divide relied on scholarly writings, decided cases in Kenya and elsewhere, as well as the history, text, and context of the 2010 Constitution. It is noteworthy to point out that the scholars themselves were not in agreement on the applicability of the doctrine. Professor Migai Akech and Professor Charles Manga Fombard supported the notion of non-applicability of the basic structure doctrine in Kenya, whilst Dr. Ojwang, Dr. Linda Musumba, and Dr. Osogo supported the notion of the applicability of the basic structure doctrine. Be that as it may, the respondents opposing the appeal expressed fear that if the legislator is left unchecked, the 2010 Constitution may be dismembered and mutilated to the extent of it being a shell of a constitution. No doubt, the respondents' deep-rooted fear is informed by the history of lack of constitutionalism in Kenya. It is for this reason that the respondents opposed to the appeal urged us to find that the basic structure doctrine is rooted in Kenya's history, text, and experience, as well as comparative constitutional theory in the form of decided cases and scholarly works. It was their argument that the courts must reconcile contradictions, draftsmanship gaps, vagueness, and phraseology in the Constitution and arrive at the conclusion that the basic structure doctrine is applicable in Kenya for the safety of the 2010 Constitution. In support of their contention, they relied on several authorities which I have set out in my judgment, and in the interest of time, I shall not go through all of them. But the ones that I brought on board into my judgment include in the matter of the Speaker of the Senate and another, Mother Kerubo Moracha versus University of Nairobi, in the Commission for the Implementation of the Constitution versus the National Assembly, where Lenaola J, as he then was, held that where the basic structure or design and architecture of our Constitution are under threat, the court can genuinely intervene and protect the Constitution, end of quote. They also relied on the decision of Jasbir Singh Rai, and as I've said, they also relied on scholarly works, in particular the works of Professor Dietrich Conrad, writing on implied limitations. In support of the contention that the Constitution also has the unspoken language, they placed reliance on scholarly writings of Yaniv Rosnai in Unconstitutional Constitutional Amendments, the Limits of Amendment Powers, where he states, and I quote, "In order to find an amendable basic principles, one has to resort to interpretation of the Constitution as a coherent whole. It is, after all, a constitution and not just a disjointed collection of constitutional pieces which must be interpreted. According to this approach, the language of the Constitution is not merely the explicit one, but also the implicit one." The respondents opposed to the appeal argued that notwithstanding the fact that the 2010 Constitution does not expressly bar amendments, it does so implicitly, as one has to pay attention to its overarching themes and/or the spirit of the Constitution. Heavy reliance was also placed on the Indian Supreme Court decision of Kesavananda, and in this Kesavananda decision, by a majority of 7-6, it was held that there are some provision in the Indian Constitution that form the basic structure of a constitution and hence are not amendable, not even when the prescribed procedures are adhered to. On the other hand, the appellants and the respondents in support of the appeal were clear. the basic structure doctrine is not applicable in Kenya. They urged us to find that the 2010 Constitution has sufficient safeguards that militate against hyper-amendments of yesteryears. The appellants and the respondents supporting the appeal also sought to rely on case law, decided cases, the history, text, and context of the 2010 Constitution. These included in the Council of Governors versus the Attorney General, where the Supreme Court stated as follows: courts may not impose a meaning that the text is not reasonably capable of bearing. In other words, interpretation should not be unduly strained. It should avoid excessive peering at the language to be interpreted, end of quote. On the invocation of the spirit of the Constitution, reliance was placed on a decision of South Africa in the decision of the Premier of KwaZulu-Natal versus the President of South Africa, where the Constitutional Court held that, and I quote, "The reliance upon the spirit of the Constitution is, in my view, misconceived. There is a procedure which is prescribed for amendments to the Constitution, and this procedure has to be followed. If that is properly done, the amendment is constitutionally unassailable," end of quote. Back home, the appellants and the also relied on the decision of Jasbir Singh Rai. They also cited the decision of the Speaker of the Senate and another, and also the decision of the Attorney General and another versus Randu Zai Rua, wherein these courts acknowledged that the people may amend the 2010 Constitution by a referendum to alter the territory of Kenya. That is to give effect to secession. They also cited the decision of the Senate and 48 others versus the Council of County Governors and 54 others. Then there is also the decision of Titus Alila and 2 others, where Fred Ochieng judge acknowledged the fact that our Constitution does indeed make provision for the amendment of the Constitution. In my view, the above decisions underscore the fact that the 2010 Constitution is amendable, subject to the process and methodology of amendment set out in Articles 255 to 257 of the Constitution being adhered to. As regards jurisprudence from foreign lands, decisions from Malaysia, from Singapore. There were also decisions from Uganda, from Zambia and Tanzania, wherein the appellants and the respondents who are in support of the appeal relied on, and all these decisions rejected the notion of the basic structure doctrine. In particular, I wish to read some part of the decision in the matter of Paul K. Semogerere and others versus the AG. This is a decision from Uganda wherein they discounted the Kesavananda decision, and this is what they said. Those who framed the Constitution also know that new and unforeseen problems may emerge. That problems once considered important may lose their importance because priorities have changed. The solutions to problems once considered right and inevitable are shown to be wrong or to require considerable modification. That judicial interpretation may rob certain provisions of their intended effect. That public opinion may shift from one philosophy of government to another. The framers of the Constitution did not put any limitations on the amending power because the end of a Constitution is the safety, the greatness, and the well-being of the people. Changes in the Constitution serve these great ends and carry out the real purpose of the Constitution. There is also the other decision from Uganda, Male Mabarizi and others, which of course also discounted the doctrine of basic structure. So in my view, the above decisions from Malaysia, Singapore, Zambia, Uganda, and Tanzania demonstrate that the courts have rejected the doctrine of basic structure on the reasoning that a constitution, being a living document, must inevitably change as society progresses. That a living constitution must be flexible to allow for a country's growth, and the review of a constitution is essential so as to cater for new and unforeseen future problems, and hence it is inadvisable to have a constitution cast in stone. To my mind, I have no illusion whatsoever that the Kenya's constitutional past was indeed dealt a death blow to multi-party democracy and turned Kenya into a de jure single-party state of the then all-powerful Kenya African National Union. The reason for the hastily carried out amendments or dismemberments of the pre-2010 Constitution are not difficult to discern. The power to amend the Constitution was provided in Section 47 of the pre-2010 Constitution, and this power was reposed solely in Parliament to the exclusion of the proverbial Wanjiku. I have cited the provisions of Section 47 of the 2010 Constitution. Our pre-2010 Constitution, like the Indian Constitution, did not bar amendability. It is against the backdrop of the Indian Constitution, where there is no provision for amendment of the Constitution by the constituent power, but the power to amend being reposed solely in Parliament, that the Casavananda decision was made. In his scholarly writings, Yaniv Rosnai traces the history of the basic structure doctrine and how it was developed in response to Prime Minister Indira Gandhi's attempt to amend the Constitution. He states, "The Indian Constitution lacks any unamendable provisions. Also, Indian jurisprudence, rooted in British tradition, initially rejected the attempts to amend the Constitution, leading eventually to the judicial development of the basic structure doctrine. According to this doctrine, the amendment power is not unlimited. Rather, it does not include the power to abrogate or change the identity of the Constitution or its basic structure," end of quotes. Yaniv Rosnai provides a further criticism of the Kesavananda case for failure to identify the unamendable clauses. He writes, "The Kesavananda case did not provide a precise list of unamendable features that constituted the Constitution's basic structure, thus forming a sort of common law doctrine that develops on a case-by-case basis." And he further stated that the Kesavananda judgment created a constitutional quicksand. In his written submissions, Professor Charles Manga Foreman, an amicus curiae on the basic structure doctrine, outlines the essence of this, what he refers to as the much acclaimed Indian basic structure. And he states, "The much acclaimed Indian basic structure doctrine owes its origin to the famous Supreme Court decision in Kesavananda decision, although the issue had been raised in a number of earlier cases. According to this doctrine, even in the absence of explicit limitation on constitutional amendment powers, Parliament's amendment powers are not unlimited. There are, as a result, implied constitutional limitations that render an amendment unconstitutional if it infringes, negates, or substitutes the basic structure of the Constitution, regardless of whether all the formal or procedural requirements of amendment have been met. End of quote. Professor Foreman points out that when the doctrine of basic structure was developed, India was dealing with, and I quote, India's 20th century independence constitution of the 1950s, whereas African courts are now dealing with made-in-Africa constitutions of the 21st century, end of quote. And that due to the changed circumstances, the Kesavananda decision is not relevant to our circumstances. This court has had occasion to express its reservations in adopting foreign concepts to our homegrown constitution. And I cite the case of Kenya Airports Authority versus Mitubel Welfare Society, where this court stated as follows: whereas citation and reliance on persuasive foreign jurisprudence is valuable, foreign experiences, values, and aspirations of other countries should rarely be invoked in interpreting the Kenyan Constitution. The progressive needs of the Kenyan Constitution are different from those of other countries. In my view, the position obtaining in India, insofar as it related to its constitution, was not any different from the position obtaining in Kenya before the promulgation of the 2010 Constitution on 27th of August 2010. The Indian Parliament has the exclusive power to amend the Constitution. Our Parliament has similar power to amend the Constitution prior to the 2010 Constitution. The situation obtaining in Kenya after the promulgation of the 2010 Constitution is different. There are explicit provisions on the amendments of the Constitution, as well as inbuilt mechanisms which limit Parliament in amending the Constitution. The methodology to amend the entrenched provisions is also clearly spelled out. There are also clearly spelled out entrenched provisions. Suffice to state that the Constitution itself anticipated that it can be amended, and it provided for its own amendment procedures. In the same Constitution, there are strictures as regard entrenched provisions which require a referendum and which ones do not. These are listed in Article 255, 1, Sub-Article A to J, and I shall not go through them. The High Court, in the impugned judgment, appreciated as much, and at part of paragraph 473 of its judgment, it stated, to be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable. However, the scheme of the Constitution, coupled with its history, structure, and nature, creates an ineluctable and unmistakable conclusion that the power to amend the Constitution is substantively limited. The structure and history of this Constitution makes it plain that it was the desire of Kenyans to barricade it against destruction by political and other elites. As has been said before, the Kenyan Constitution was one in which the Kenyans bequeathed themselves in spite of and at times against the political and other elites. Kenyans therefore were keen to ensure that their bequests to themselves would not be abrogated through either incompatible interpretation, technical subterfuge, or by the power of amendment unleashed by stealth. End of quote. In my view, whereas the High Court correctly found that there are no explicit provisions in the 2010 Constitution barring amendments, the judges erred in finding that the bar to amendment is implicit. As stated above, the pre-2010 Constitution did not have provision for the amendment of the Constitution by way of a popular initiative, and neither did Parliament recognize the notion of implicit unamendability. Indeed, the issue in Joya and others versus the Attorney General was whether the Parliament could, in the exercise of its amendment power under Section 47 of the Constitution, repeal the Constitution. I have cited a passage from that decision of Njoya decision that is relevant to this judgment. It is the Njoya decision that paved the way for the amendment of the pre-2010 Constitution by constituent power via a referendum. This was in recognition of the supremacy of the sovereignty of the people, who then exercised that sovereignty in the referendum that birthed the 2010 Constitution. In my view, the Njoya decision was our Kesavananda moment, and to paraphrase Yaniv Rosnai, this may have been as a result of the late President Kenyatta's and the late President Moi's far-reaching attempts to amend the Constitution, and there was need to curb those excesses. As history will attest, the clamor for a new constitution was long and arduous. But that notwithstanding, when the Kenyan people finally bequeathed themselves with a new constitution, they ensured that it would be free from hyper-amendments. Indeed, the 2010 constitution was informed by Kenya's dark past, and its citizenry were determined never again shall we have a constitution that can be amended at will. In the formulation of the 2010 constitution, a conscious effort was made to ensure that we do not have hyper-amendments. This conclusion is supported by findings contained in the final report of the Constitution of Kenya Review Commission, CKRC, which mirror Chapter 16 of our Constitution. I've reproduced part of the reports of CKRC that mirror Chapter 16 of our Constitution. Following the recommendations of CKRC and true to word, Chapter 16 of the 2010 Constitution is dedicated to amendment of the Constitution. In my view, the clear text and language of Chapter 16 is that there are explicit provisions in the 2010 Constitution providing for amendment, and therefore there is no reason to look outside the Constitution and import the basic structure doctrine on the basis that the Constitution has the unspoken language and or implicit provisions. And it has now been slightly more than 10 years since the Constitution was promulgated, and to the credit of the drafters of the Constitution, the 21 attempts to amend the Constitution, 19 were through a parliamentary initiative, whilst 2 were through a popular initiative, have all fallen by the wayside. These 21 attempts are tabulated in the written submissions of Mr. Ogeto, the Solicitor General appearing for the Honorable Attorney General. I have also reproduced those 21 attempts in part of this, my judgment. It is also true that the framers of our Constitution balance between flexibility and rigidity. To this end, CKRC had recommended, and I quote, that there is need to protect the Constitution against indiscriminate amendments. If the amendment procedure is too simple, it reduces public confidence in the Constitution. The converse, however, is also true. If the amendment procedure is too rigid, it may encourage revolutionary measures to bring about change instead of using the acceptable constitutional means. Thus, a balance must be struck between these two extremes. End of quotes. Accordingly, a balance had to be struck to avert violent revolutions against abusive amendments. In an article, The Politics of Constitutional Change in Kenya Since Independence, 1963 to 1969, Professor Okoth Ogendo underscores the fate of post-independence constitutions. He writes, "Constitutional systems in Anglophone Africa have not had a happy history, especially during the last decade. Almost without exception, the independence documents have either ended up in military dustbins or have undergone change so profound and rapid as to alter their value, content, and significance beyond recognizance, end of quote. I hear the good professor saying the Independence Constitution was so badly dismembered, and that if they did not suffer the fate of dismemberment, it was more likely that the Constitution would find their way into dustbins following military coups. The writings of Professor Okoth Ogendo echo the profound words of John F. Kennedy in 1962 when he stated, and I quote, "Those who make peaceful revolution impossible will make violent revolution inevitable," end of quote. It is no secret that the framers of our 2010 Constitution struck a balance between stability and instability by providing for amendments in Chapter 16 of the 2010 Constitution, and this being the supreme law of the land, it was desirable to give it a more stable character and free it from hyper-amendments. This is important as no society is static, and what is good for one generation may not necessarily be good for the next. In an article entitled "No Generation Has the Right to Impose Its Own Values and Political Principles on a Later Generation" by Professor Forman, he cites another scholar, Colvin De Silva, who states as follows: "Constitutions are made in terms of the stage of development at which any given society or country has arrived. In terms of that stage of development, it looks upon things, and for any generation of people to imagine that it can so completely project itself into infinity of the future, so as to be able to decide its own generation that it will constrain a future generation or generations forever within the confines of its own postulates, is to make a mistake of thinking that any human collectivity is the equivalent of the divinity," end of quote. He concludes, "It is unlikely that the framers of the new or revised African constitutions wanted to prevent future generations from repealing these constitutions. A constituent body is omnipotent only to the extent that it has no power to destroy or limit the omnipotence of a future constituent body. In short, the present and future generations should not be ruled by the dead hand of their ancestors," end of quote. I think it behooves us to recognize that in spite of the supremacy of constitutions, we cannot and should never legislate from the graves, what Professor Forman refers to as the dead hand. We cannot possibly shackle future generations but by what we consider to be noble today. The other troubling aspect of the impugned judgment is that the High Court came to the conclusion that whatever is amendable will be decided on a case-by-case basis. And this is what they said: whether a particular clause in the Constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution, its foundational structure, its text, its internal coherence, the history of the clause and the constitutional history, and other non-legal consideration permitted by our canon of constitutional interpretation principles," end of quote. The above finding, in my view, poses difficult questions. Who is to carry out the fact-intensive determination? And at what stage in the process of constitutional change? The appellants told us, and rightly so in my view, that in terms of seeking an advisory opinion, Wanjiku has no place, as by dint of Article 163, Sub-Article 6, this is a preserve of the national government, a state organ, or a county government. I reproduce therein the provision of that article. Since Wanjiku does not have the luxury of approaching the Supreme Court under Article 163, Sub-Article 6, how does Wanjiku get to have an issue subjected to fact-intensive determination? Sight should also not be lost that judges, being human, are not infallible, and they should not arrogate unto themselves the unfettered power to validate or invalidate amendments on the basis that they are eternal causes from their preferred reading of the Constitution. If for a moment we were to find that judges are fallible, where will be the unwritten constraint? The absence of constraint, no doubt, leads to uncertainty and absurdity. In an article by Adan Kasia Abebe entitled "The Substantive Validity of a Constitutional Amendment in South Africa," appearing in a South African journal, I'll just read part of what he said in that article. The idea of a judicially enforceable implied limits on the power of constitutional amendment is particularly unacceptable in cases where a constitution explicitly outlines the fundamental principles and subjects such principles to amendment, as is the case in South Africa. In the absence of a clearly defined and enforceable substantive limits, the judicial control of constitutional amendments will lead to a situation where courts effectively arrogate the role of the people and their elected representatives in defining a polity's fundamental values over which there may be a reasonable disagreement. The absence of clearly defined limits also means that every constitutional judge will have his or her own list of what is basic and what is not. The judicial power to define basic social and political values belies the ideal that courts should merely apply settled rules and principles and not discover some vague fundamental values to invalidate the best judgments of the overwhelming majority of the political representative. In the absence of clearly established substantive limits and an explicit jurisdiction to enforce substantive limits on constitutional amendments, the power and responsibility of ensuring compliance with any desirable substantive limits lies beyond the courtroom. Only the democratic process or a revolution could legitimately and effectively stymie any attempt to legitimize undemocratic behavior through constitutional amendments, end of quote. Similar sentiments on infallibility of judges are expressed in an article entitled "The Conundrum of Unconstitutional Constitutional Amendments" by Paul Jen Yap, and he states, "The people may not always be right, for popular sovereignty is not an absolute guarantee of substantive justice, but neither are judges infallible in their moral deliberations. In these circumstances, the judiciary must cede to the expression of popular sovereignty, not merely because the amendment is an unmistakable expression of public will, but because this convergence of interests is undisputable evidence of the triumph of the political process over the intervening institutional and electoral barriers erected by the separation of governmental powers," end of quote. In my view, it is not correct to elevate judges to the status of demigods, and just as it is possible to have a distrustful and rogue parliament, it is also possible to have a rogue and distrustful judiciary, more so bearing in mind that the latter are not elected as the people's representative. I know that as Kenyans, we love to demonize our elected political leaders. We do this all the time, but rarely do we stop to remember we get the leaders we deserve. I am therefore of the persuasion that the contest of what is amendable and what is not should not be left to be a matter of judicial innovation. Judges, just like parliamentarians, cannot assume supremacy over all others, as indeed it is the people who are sovereign. Article 1, Sub-Article 1 of the 2010 Constitution screams out, "All sovereign power belongs to the people of Kenya and shall be exercised in accordance with this Constitution," end of quote. The people of Kenya, in the exercise of their constituent power in a referendum, voted for the amendment of the pre-2010 Constitution. In came the 2010 Constitution with provisions on how it can be amended in accordance with this Constitution. On the ultimate expression of the will of people, I find an article by Yaniv Rosnai on constitutional amendments to be telling. And allow me to read this passage. He says, constitutional amendment seems puzzling. The Constitution is the highest positive legal norm. The power to amend the Constitution presupposes the same kind of power as the one to constitute a Constitution. It is a supreme power within the legal system, and as such, it can reach every rule or principle of the legal system. If this power is indeed supreme, how can it limit itself? If it is limited, how can it be supreme? This is the legal equivalent of the paradox of omnipotence. Can an omnipotent entity bind itself? Both positive and negative answers to these questions lead to the conclusion that it is not omnipotent. Moreover, if the amendment power is a kind of constituent power, then it remains unclear why a prior manifestation of that power prevails over the later exercise of a similar power. Quite the reverse, according to the principle, a later norm should prevail over a conflicting earlier norm of the same normative status. Finally, the Constitution, which expresses the people's sovereign power, binds and guides ordinary law, which expresses the Parliament's ordinary power. The common meaning of unconstitutionality is that an ordinary law, inferior to and bound by the Constitution, violates it. How can unconstitutionality refer to an act carrying the same normative status as the Constitution itself? The question posed by Yaniv Rosnai is, the question that he has posed, why a prior manifestation of that power prevails over the latter exercise of a similar power, underscores the people's will to amend the Constitution without a prior manifestation of that power prevailing over the subsequent exercise of a similar power. Suffice to state that in the 2010 constitutions, Kenyans recognize their constitutional right to amend the Constitution as long as this is done in the manner provided in the Constitution. If perchance the framers of our Constitution had intended that there be a limitation on the power of amendment, they would have provided as much. There are no such limitations in Chapter 16 of the Constitution. And at the risk of being repetitive, I reiterate there is no clause in the 2010 Constitution that prohibits amendments, but there is an inbuilt mechanism that provides safeguards, and I'm of the persuasion that the High Court erred in imposing another hurdle on the basis of an implied provision anchored on the spirit or overarching theme of the Constitution. In my view, the High Court erred in invoking the spirit of the Constitution without the need to do so, given the clear and ambiguous language of the 2010 Constitution on amendments. It is also my view, as explained above, that the findings of the High Court were not supported by the context, structure, and history of the Constitution 2010. The upshot of the above analysis is that the appellant's appeal on the non-applicability of the basic structure is for allowing. However, this is subject to the majority decision of this court. So much as relates to the issue of the basic structure. The next, I shall then proceed now to look at the role of the President, the role of His Excellency, the President in the BBI process. I think for a start, for me, the beginning point is Article 131(2)(c) of the Constitution, which requires the President to promote and enhance the unity of the nation. And with the noble intention, on 9th of March 2018, His Excellency the President, Uhuru Muigai Kenyatta, held talks with the former Prime Minister Raila Odinga that culminated in what is now commonly referred to as a handshake. The intention of the handshake was to bring to an end the political disharmony, demonstration process, and disgruntlements that arose with the outcome of the presidential elections held in August 2017. The handshake would then become a political tool to calm the nation that was deeply divided and to allow for consensus building. I think the history about the formation of the task force as well as the formation of the steering committee were well captured in the introductory part of this judgment that was done by the President of the Court. And I will not repeat that. But suffice to state that it is not in dispute that the Task Force on Building Bridges to Unity Advisory Task Force was appointed by His Excellency on 24th of May 2018, and subsequently this gave way to the steering committee, and that the process leading up to the formulation of the Constitution of Kenya Amendment Bill 2010 in my view, was largely driven by the executive, as it is difficult to truncate the BBI task force and the BBI steering committee from the submissions of the letter by Honorable Junet Mohammed and Honorable Waweru as promoters of the Constitution of Kenya Amendment Bill 2020. It is clear that one thing led to the other until the culmination of the letter of 18th November 2020 by Honorable Junet Mohammed and Waweru and Honorable Waweri to the Iebc seeking approval of the format to be used in the collection of signatures. Article 256 and 257 of the Constitution provide for amendments by way of a parliamentary initiative and not a popular initiative. The proposals by Honorable Junet and Honorable Waweru would best have been channeled through a parliamentary process, as they were heavily laden with the executive arm. The route of popular initiative was not open to them, as this was not a Wanjiku-driven process. There was an alternative argument that although His Excellency the President Uhuru Kenyatta, was not a promoter of the Constitution of Kenya Amendment Bill, it was contended that nothing stops him from being a promoter of a popular initiative in his own personal capacity, as it may well be possible that a president may find himself in a peculiar position that she does not enjoy the support of Parliament, hence he would be locked out of both the parliamentary as well as the popular initiative. Mr. Kiragu Kimani, Senior Counsel, while urging the appeal on behalf of His Excellency, submitted that the President under Article 38 of the Constitution of Kenya has a right to make political choices just like any other Kenyan, and that the term initiator that was used by the High Court in reference to His Excellency the President was not recognized in the Constitution, and that there was nothing that barred the President from being a promoter of the bill, that the President has a right to campaign for any political party or cause. Further, that Article 12 of the Constitution provides that every citizen is entitled to the rights, privileges, and benefits of citizenship, subject to the limits provided or permitted by this Constitution, end of quote. It was contended that if we were to find that His Excellency the President in his personal capacity cannot use the route of a popular initiative, then this would be tantamount to denying him his rights as a citizen. In my view, the balancing of the rights of a sitting president poses a challenge, as it is difficult to make a demarcation when a president is acting in his personal capacity vis-a-vis his official capacity. Can a president cease to be a president without handing over power during the tenure of his office? In the circumstances of this case, we were told that His Excellency Honorable Uhuru Kenyatta was not the promoter. Indeed, the High Court acknowledged that His Excellency the President was not the promoter, and they coined the term initiator, a term not anywhere in the constitutional amendment process. Be that as it may, the question to be answered is whether His Excellency the President can be a promoter of an amendment bill. In my view, I would liken the situation to that obtaining in the military, where military personnel are often said to be children of a lesser God, to the extent that some of their fundamental rights are limited by virtue of their joining the military. Regrettably, by conduct, there are limitations placed on public officers as to what they can do and what they cannot do. I liken the position of His Excellency the President to that of a judge, where one is a judge 24/7, and it is difficult to say when he or she is not acting in his official capacity. Given the above, it is my humble view that His Excellency the President cannot therefore be a Wanjiku for the purposes of Article 257 of the Constitution, and to this extent I'm in agreement with the High Court findings that His Excellency the President cannot initiate changes to the Constitution through a popular initiative as provided in Article 257. The third item that I will go into is the issue of the legality of the BBI task force and the BBI steering committee. As to the issue of the legality of the BBI task force and the steering committee, and as explained above, the task force and the steering committee were born out of noble intentions of His Excellency the President. Both were ad hoc committees appointed by His Excellency the President for purposes of advising him on the discharge of his constitutional mandate in fostering unity in the nation. The question of illegality of the BBI task force had actually come for consideration before Mativo J, who had considered this issue and had come to the conclusion that His Excellency the President acted within his powers under Article 131 and 132 of the Constitution. This was in the case of Third Way Alliance. I've also had the advantage of reading the draft judgment of my sister, Okwengu J.A., and I'm in agreement with the sentiments expressed therein that the BBI task force and the BBI steering committee were not illegal outfits. On the issue of the presidential immunity, I shall not take much time on this, save to agree with what the High Court said, that when it comes to civil proceedings, the President is not insulated if he does anything or fails to do anything in his own personal capacity. Then there is the issue of the quorum of Iebc. On the question of quorum of Iebc, the appellants and the respondents in support of the appeal challenged the High Court findings that the Iebc was not quorate for purposes of its business, including the verification of signatures in support of the Constitution of Kenya Amendment Bill 2020. For a start, the Iebc is an independent constitutional commission established pursuant to Chapter 15 of the 2010 Constitution. Article 250, Subarticle 1 sets out the composition of an independent commission. It reads, each commission shall consist of at least 3, but not more than 9 members. On the other hand, Section 5 of the Iebc Act provides that the commission shall consist of a chairperson and 8 other members appointed in accordance with Article 250, Subarticle 50 of the Constitution and the provision of this Act. What I would like to say as regards this issue, or my finding, is that the Iebc, as currently constituted with 3 members, cannot be said not to be constitutionally compliant. And the question that I ask myself, if with 3 members, the commission is constitutionally compliant, and it can continue to operate because it is constitutionally compliant, in circumstances like those, can one really say that for purposes of carrying out its deliberations, the members of a quorum in a meeting must be 5? In my view, I think the constitutional provisions take precedence, and if the commission, as currently constituted, is constitutionally compliant, it can carry out its mandate with the 3 members of the commission, I think it would be absurd to say that it must have, for it to be correct, there must be 5 members. I've also made comments on the 2 cases of Biwott, as well as the case decided by Mwita, as well as the one that was decided by Okwany. But additionally, it is my considered view that the issue of verification of signatures is not a matter requiring a policy decision. The functions of Iebc are spelled out in Section 4 of the Act, and they are numerous. In my respective view, the verification of signatures is not a matter that arises out of the resolution or decisions made by the commissioners at a meeting of the commission, but one dictated by the operation of the law, as the process of verification of signatures is not a policy decision to require the Iebc to be correct. In my view, it cannot be said that in performing such mundane tasks as the continuous education of voters would require the Commission to be correct, more so bearing in mind that the Commission has a secretariat that undertakes its day-to-day operations. I am therefore of the considered opinion that the verification of signatures was not null and void for lack of quorum, and neither was it a function that required a policy decision. Then there was a question of the role of Iebc in a popular initiative. In paragraph 733 of the impugned judgment, the High Court found that the Iebc's role include verification of signatures and not mere ascertainment of numbers of registered voters whose signatures accompany the popular initiative bill. It would follow that the Iebc would need some legal or regulatory framework to guide it in its operation. On the other hand, if the Iebc role is the venial administrative task of ascertaining numbers, then perchance no further legal or regulatory framework would be required. The court proceeded to define what verification is, and this is what they said. The only reasonable meaning of the term verify, as used in Article 257(4) of the Constitution, includes both the ascertainment of numbers and confirming the authenticity of the signature submitted. The role of Iebc is spelled out in Article 257 of the Constitution. In the matter before us, we were told that the Iebc carried out verification by removing names that did not have signatures. They also removed names that did not have the national identity cards or passport numbers. They removed duplicated numbers and asked the promoters to depone affidavits, to have affidavits deponing that the signatures were collected with the consent of the parties. I have in this judgment reproduced a format of the collection of signatures that was submitted by Honorable Junet Mohammed and Honorable Waweru to Iebc, and it was approved. And that format captured the following details. One had to include their name, their ID or passport number, their county, their constituency, their county assembly ward, the polling station, their mobile numbers, their email address, and then they also had to sign or to thumbprint. Article 257, sub-article 4 did not, in my view, envisage a forensic examination on the authenticity of the signatures, more so bearing in mind that Iebc does not have a repository of signatures. But even if it had, in my view, it would be a Herculean task to undertake. For instance, the verification would require that Iebc obtains non-signatures of those who appended their signatures to the initiative. The non-signatures would then be subjected to forensic investigation by handwriting experts. Given that the Iebc published the list of those said to have supported the initiative, what was so difficult for one to say that they did not append their signatures? In my view, to place near impossible demands on Iebc would, as it were, greatly cripple the operations of Iebc. On the question of continuous voter registration, the High Court found that there had been no evidence that the Iebc had sensitized citizens that there was continuous voter registration. It is this finding that led to Declaration Number 9 in their judgment, wherein the court declared that the Constitution of Kenya Amendment Bill cannot be subjected to a referendum before the Iebc carries out nationwide voter registration exercise. Mr. Morara Omoke, the 76th respondent, urged us inter alia that the Iebc could not conduct a referendum before conducting nationwide voter registration, as this would disenfranchise many voters. The Iebc, on the other hand, argued that it had been continually conducting voter registration at the constituency level. Article 88, Subarticle 4 requires Iebc to undertake continuous registration of citizens as voters. Suffice to state that this is an ongoing process, and it is upon every Kenyan who attains the age of 18 to register as a voter. It is the same registered voters who vote in an election that also vote in a referendum. Indeed, the 1 million persons who support an initiative are registered voters. Further, there is a distinction between the time and place of an election vis-a-vis the time and place of a referendum in the 2010 Constitution provides for an election cycle. We know that elections are carried out after every 5 years. Not so when it comes to a referendum, as there is no defined time when a referendum is to be held. In my view, the fact that Iebc carries out continuous voter registration, it cannot be said that they fail to carry out nationwide voter registration when we know that the time and place of a referendum, unlike an election, is not known and cannot be defined with specificity. Then, on the question of creation of new constitution, as regards the issue of creation of 70 new constituencies, in Declaration Number 14, the High Court held that the Constitution of Kenya Amendment Bill is unconstitutional insofar as it proposed to predetermine the allocation of 70 more constituencies. It held it is unconstitutional for a Constitution of Kenya Amendment Bill to directly allocate and apportion constituencies in contravention of Article 89 of the Constitution. Indeed, that provision was in Clause 10 of the Amendment Bill. Article 89, Subarticle 1 of the 2010 Constitution provides that there shall be 290 constituencies for the purposes of the election of members of the National Assembly provided in Article 97(1)(a). The respondents opposed to the appeal contested this part of the bill on the basis that it sought to amend Article 89(1) of the 2010 Constitution. Firstly, it is important to say that the High Court held that Article 89, Subarticle 1 of the 2010 Constitution is not what they were calling an eternity clause, and they said that it is amenable to amendments subject to due process being followed. They stated as much at paragraph 670 of the judgment. I shall not go over it. It is clear that the court recognized, and rightly so in my view, that Article 89(1) of the 2010 Constitution is amenable to amendment. Having so recognized, was it unconstitutional for the Constitution of Kenya Amendment Bill to purport to create 70 more constituencies? In my view, once we appreciate that Wanjiku can seek to amend any provisions of the Constitution as long as the procedure set out in Articles 255 to 259 of the Constitution is adhered to, then the Kenyan people have the right to reduce or increase the number of constituencies to ensure that there is no underrepresentation. They can even vary the mandate of Iebc. Further, the functions of Iebc are spelled out in Section 4 of the Act, include delimitation of constituencies and wards in accordance with this Constitution. Black's Law Dictionary defines delimitation as the act of making a boundary or fixing a limit. Suffice to state that the Constitution of Kenya Amendment Bill 2020 did not seek to make boundaries or fix the limits of a boundary, but increase in the number of constituencies. The allocation of increased constituencies is not, in my view, delimitation. And clearly, the Iebc has no role to play in the creation of constituencies. And the upshot of the above analysis is that the second schedule to the Constitution of Kenya Amendment Bill 2020 in seeking to determine the creation of 70 more constituencies, in my view, not unconstitutional. We shall then look at the Iebc regulatory framework, and I will not go into great details on this, but suffice to state that the Constitution, the Iebc Act, the Elections Act make provision as regards the conduct of a referendum. And it is my considered opinion, and contrary to the findings of the High Court, that there is legislation pursuant to the Constitution, the Independent Electoral and Boundaries Commission Act, and the Elections Act to govern the collection, presentation, and verification of signatures, and a legal framework to govern the conduct of a referendum. Indeed, the High Court appreciated as much when at paragraph 783 of the judgment, they stated as follows, and I quote, "Notwithstanding the absence of an enabling legislation as regards the conduct of referenda, such constitutional process may still be undertaken as long as the constitutional expectation, values, principles, and objects, especially those in Article 10 of the Constitution, are met," end of quote. Besides, in the titles Alila and two others case, and two others versus the Attorney General, the High Court had held, and I quote, "Secondly, I find that the Constitution has already set up a proper legislative framework for holding a referendum." And the court further stated, that is the High Court, further, there are explicit provisions in the Elections Act which govern the conduct of referendum in Kenya, end of quote. In the impugned judgment, the court had endorsed the findings in the Alila decision. At paragraph 603 of the judgment, it stated, "Though we have found that it is necessary to enact Referendum Act, we do not subscribe to the school of thought that absence of legislation implementing a provision of the Constitution renders such a provision inoperative and unenforceable. On that finding, we agree with the decision in titles Alila and two others." And at paragraph 6 of 6, the court stated, "It is, however, our view, and we hold that notwithstanding the absence of an enabling legislation as regards the conduct of referenda, such constitutional process may still be undertaken as long as the constitutional expectation, values, principles, and objects are met," end of quote. In my view, it is surprising that having found so, the High Court proceeded to make a declaration to the effect that a declaration is hereby, this is what they said, "A declaration is hereby made that the absence of legislation or legal framework to govern the collection, presentation, and verification of signatures and the conduct of referenda in the circumstances of this case renders the attempt to amend the Constitution of Kenya through the Constitution of Kenya Amendment Bill 2020 flawed," end of quote. In my view, it is my view that the Iebc existing statutory framework as well as the administrative procedures established therein was sufficient for purposes of carrying out a referendum. However, I am alive to the fact that there are two referendum bills that are pending before Parliament. It is my considered opinion that notwithstanding the fact that these bills have not been passed and fully debated by Parliament, it cannot be said that there was no regulatory framework to govern the conduct of a referenda. Consequently, it is my finding that there is legal framework to govern the collection, presentation, and verification of signatures, as well as the conduct of referenda. The other aspect is the issue of whether His Excellency, the President, was served with the petition and the hearing notices. And in my view, I think this is a fairly straightforward matter. There was at no point was the High Court told that shown any return of service or affidavit of service in respect of service upon His Excellency. What Mr. Oluchwer had said is that he had used an email address, and although Mr. Oluchwer had said he sued him in his personal capacity, that address seemed not to have been a personal address. But even notwithstanding that, it was imperative upon the court, once it came to the conclusion that the Attorney General could not appear for the President, to have ascertained at that point in time that His Excellency the President had been served with the hearing notice or with the petition. In my view, His Excellency the President was entitled to equality and freedom from discrimination as per the dictates of Article 27(1) of the Constitution, which provides for equality and freedom from discrimination. And then there is also Article 25(c), which provides for a fair trial as a fundamental right. In my view, the right to be heard is enshrined in the 2010 Constitution, and no one can be deprived of this right. This court has underscored the right to be heard in the decision of Onyango Olo versus the Attorney General, when it held that the principle of natural justice applies where ordinary people reasonably expect those making decisions which will affect others to act fairly, and they cannot act fairly and be seen to have acted fairly without giving an opportunity to be heard. A decision in breach of the rules of natural justice is not cured by holding that the decision would otherwise have been right, since if the principle of natural justice is violated, it matters not that the same decision would have been arrived at. Denial of the right to be heard renders any decision made null and void ab initio. In my view, it matters not that His Excellency Honorable Uhuru Muigai Kenyatta is the President of the Republic of Kenya. He is entitled to the protection of the law, as the law protects the weak as well as the strong. It was wrong for the High Court to have proceeded with the hearing and thereafter make adverse findings against His Excellency Honorable Uhuru Kenyatta without ascertaining whether he had been served, either with the petition and or the subsequent hearing notice or hearing notices. With regard to issues raised by Mr. Morara Omoke, whether the bill violated Article 43(1)(a) of the Constitution in view of the COVID-19 pandemic, whether both or either of the Houses of Parliament were infirmed from considering the constitutional amendment bill in view of the Chief Justice's advisory opinion for the dissolution of Parliament, and whether the petitioners had made out a case for disclosure and publication of the BBI Steering Committee's financial information. I've had the advantage of reading the lead judgment by Musinga J.A., the President of the Court, on these issues, and I entirely agree with him. I've made a few comments, but in the interest of time, I will not go through those comments. And on the appeal by the Kenya National Union of Nurses, the 15th respondent herein, the gist of their complaint was that whereas their views had initially been included in the BBI task force, the same did not find its way to the Constitution of Kenya Amendment Bill 2020. They supported the appeal and urged us to find that the amendment process was legal and constitutionally sound, and faulted the High Court for finding that the basic structure doctrine applied in Kenya. As stated above, the 15th respondent's grievance is that whereas the abuse of having an independent commission were initially captured in the BBI task force, these views were subsequently omitted. In my view, this is a fairly straightforward issue. If the 15th respondent would like an amendment of the 2010 Constitution to have itself included as an independent commission, they can take advantage of the provisions of Article 257 of the Constitution. They cannot ride on an initiative of another and complain that their views have been left out. In any event, the fact that their views were contained in the BBI task force did not create any legitimate expectation on their part. I shall say no more on this issue, save to state that the appeal is devoid of merit and it is accordingly dismissed. Those are my views. Thank you.
Thank you, my sister, Justice Sichale. We will now have my brother, the Honorable Mr. Justice Gatembu, summarize his judgment.
Thank you. Thank you very much, President. I think at the conclusion of the argument, last time we sat here, you told us that when we retire, we can consider your submissions and other material. Now, I think it is my turn to say that when you retire, you can read our judgments in full. So I'll give you just a short synopsis of what I have said in my judgment. So this is what I have said. In this judgment, I only address some of the issues arising from the consolidated appeals. I do so under 6 broad themes. The first is the question of applicability of the basic structure doctrine to Kenya. Second is the question of the scope of popular initiative under Article 257 of the Constitution and the place of public participation in that regard. Under that, there is a question whether it is open to the President to propose or initiate amendment of the Constitution through popular initiative route, and whether the amendment process used in this instance, the BBI process, is constitutional. The third area I will address is in relation to Iebc, its role in the popular initiative process, whether there is adequate legal infrastructure to enable Iebc to conduct the referendum under Article 257 of the Constitution, whether Iebc's administrative procedures are adequate to enable it to undertake its verification role, whether it had quorum to conduct business in that regard, and whether it is under a duty to conduct nationwide voter registration before carrying out the referendum. I'll also address under this theme the question of whether a single or multiple questions should be framed for the referendum. The fourth area is in relation to matters concerning the President. Does the President enjoy absolute immunity from civil proceedings under Article 143 of the Constitution? And was his right to fair hearing violated, and was he condemned and heard? And the fifth area I will touch on is on the amicus curiae, whether the High Court was wrong in admitting them in the proceedings. And sixth is the question whether the High Court wrongly exercised jurisdiction in the matter by reason of doctrines of mootness and ripeness, political questions, and constitutional avoidance, and deference to other state organs. So I begin with the basic structure doctrine, and I reproduce there, and I will not read what the High Court said. I then look at the arguments from both sides, and then I say this. In terms of identification of the basic structure in the Constitution, the Court stated that it consists of the foundational structure of the Constitution as provided in the preamble, the 18 chapters, and the 6 schedules of the Constitution, which form the fundamental core structure, values, and principles of the Constitution, which cannot be amended without recalling primary constituent power of the people. This structure, the Court stated, outlines the system of government Kenyans chose, including the design of the judiciary, parliament, the executive, the independent commissions, and other offices, and the devolved system of government, and includes the provisions on land and environment, leadership and integrity, public finance, and national security. I then reproduce there at length what they say. To illustrate the distinction between unamendable and amendable constitutional provisions, the court cited Article 2(1) of the Constitution, which provides that the Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government, as an example of an amendable or eternity clause, which can only be changed through exercise of primary constituent power on the ground that it expresses a core and fundamental principle of the Constitution. In contrast, the court stated Article 2, sub 5 of the Constitution, which provides that the general rules of international law shall form part of the law of Kenya, is also part of the basic structure, and that the spirit or the core meaning or value of that clause cannot be changed without involving the primary constituent power. It may, however, be amended through the secondary constituent power under Article 255 to clarify its meaning. The other example given is Article 89(1) of the Constitution, which provides that there shall be 290 constituencies, in respect of which the court expressed that its core meaning and import can only be changed through primary constituent power, but the actual number of constituencies can be increased or reduced through either secondary constituent power or constituted power. I then set out the arguments that have been made on either side on applicability of the doctrine, and then I go on to say as follows. Having considered those arguments, the question whether the High Court correctly determined that the doctrine of basic structure is applicable in Kenya is a difficult one. The arguments advanced by learned counsel on both sides are powerful and most persuasive. The following, however, is the view I take. In his book, Constitutional and Administrative Law, D. Smith argues that although written constitutions differ widely in their purposes, form, and content, they will normally be found to have two characteristics in common. Namely, there will be the fundamental law of the land, and there will be a kind of higher law and the legal source of legitimate authority. A higher kind of law in that the law set out in the Constitution will be hierarchically superior to other laws and will not be alterable except by a specially prescribed procedure for amendment. Chapter 16 of the Constitution, titled Amendment of this Constitution, prescribes the procedure for amendment of the Constitution. Article 255(1) stipulates that a proposed amendment to the Constitution shall be enacted in accordance with Article 256 or 257 and approved in accordance with Clause 2 by a referendum. If the amendment relates to the matters that are set out under that article, which I then reproduce. Article 256 sets out the amendment process through a parliamentary initiative, while 257 sets out the amendment process by popular initiative. On the face of it, those provisions of Chapter 16 of the Constitution would appear clear and unambiguous, and construed in their natural and ordinary sense would mean that every provision in the Constitution is amendable, provided the stipulated process of amendment is followed. However, Article 259 of the Constitution commands that the Constitution shall be interpreted in a manner that promotes its purposes, values, and principles, advances the rule of law and human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. Article 10 of the Constitution commands that in applying or interpreting the Constitution or any law, the national values and principles of governance set out in that article, including the rule of law, democracy, and participation of the people, bind all organs, state officers, and all persons. Earlier, the same principle of constitutional interpretation was expressed by the Court of Appeal in Tanzania in the Dianabo case, and I have reproduced portions of that. I have also cited the Supreme Court decision in the matter of interim independent commission, which expressed that rules of constitutional interpretation do not favor formalistic or positivist approaches, and that every style of constitution compels a broad and flexible approach to interpretation. And I reproduce segments of that judgment there. Given those principles of constitutional interpretation, the High Court was right in the methodology it employed in interpreting the constitutional provisions from a historical and contextual perspective and the complaint that the court misapprehended the methodology applicable is not well-founded. What then is the doctrine of basic structure, and was the High Court right in holding that it applies in Kenya? In an article for the Center for Public Interest Uganda titled "The Basic Structure Doctrine and Constitutional Restraint Take Away from Age Limit Decision," Benson Tusariwe writes that the doctrine of basic structure holds that the Constitution has certain basic features which underlie not just the letter, but also the spirit of that Constitution. These features constitute the inviolable core of the Constitution, and any amendment which purports to alter the Constitution in a manner that takes away that basic structure is void and of no effect. That even without explicit limitations to the constitutional amendment power, there are implied constitutional limitations to the nature and scope of constitutional amendments by which the Constitution should not be amended in a way that changes features of the Constitution that form its basic structure. The doctrine rests on the distinction between original or primary power to make or effect radical changes in the Constitution vis-à-vis secondary power to amend or effect minor changes on the Constitution. Under the doctrine, the decision to make fundamental changes to the Constitution is a matter solely reserved for the people, the Constituent Assembly. Courts may invalidate any exercise of the derivative amendment power that proposes to violate the Constitution's basic structure. Constitutional amendments may be found to be infirm because of the actual proposed content of the amendments that will replace the Constitution and not just amend it. Yaniv Rosnai, who was widely quoted by counsel in both sides in this case, states in his book, Unconstitutional Amendments, The Limit of Amendment Powers, that under the doctrine, the amendment power is not unlimited. Rather, it does not include the power to abrogate or change the identity of the Constitution or its basic features, and that any organ established within the constitutional scheme to amend the Constitution, however unlimited it may be in terms of explicit language, cannot modify the basic pillars underpinning its constitutional authority so as to change the Constitution's identity. The other phraseology used in reference to the doctrine of basic structure is quote-unquote unconstitutional constitutional amendments, UCA. In the article, Democratic Erosion, Populist Constitutionalism, and the Unconstitutional Constitutional Amendments Doctrine, Yaniv Rosnai again, with Tamar Brandes, argue, and I quote, "One feature of modern constitutionalism that is especially relevant for constitutional change is that of constitutional unamendability. Constitutional unamendability refers to the limitations or restrictions imposed upon constitutional amendment powers from amending certain constitutional rules, values, or institutions," end of quote. They argue that unamendability may appear in the form of an explicit, unamendable constitutional provision, or may also be judicially imposed when the court derives such limitations implicitly from the Constitution, declaring that certain constitutional changes are strictly prohibited. They say that unamendability aims to protect the core values of the Constitution that express, in a way, its constitutional identity. And again, I have quoted from their work there at length. The doctrine, therefore, distinguishes amendment, properly so called, and dismemberment of the Constitution. Again, I cite a passage which I think has already been referred to by one of my colleagues from Richard Albert, Constitutional Amendments, that makes the point. As is evident from the material presented by both sides of the argument, the doctrine of basic structure is not new to our jurisprudence. It was acknowledged and applied by Rengera J. in the case of Joya and others, in the context of determining whether Parliament could enact a new constitution in exercise of its amendment power under Section 47 of the retired Constitution. Section 47 of the retired Constitution provided that subject to that section, Parliament may alter the Constitution. Justice Rengera found that Parliament had no power under the provisions of Section 47 of the Constitution to abrogate the Constitution and or enact a new one in its place. In reaching that conclusion, the judge found support in the dicta from the Supreme Court case of Kesavanda. And I have quoted that and also passages from Minerva Mills Limited. And then I have said as follows. In the end, Rengera J endorsed the view that every provision in the Constitution could be amended, provided in the result, the basic foundations and structure of the Constitution remains the same. And there are other passages from that decision that have already been cited, and so I will skip them. There is also the decision of the High Court in the case of Commission for Implementation of the Constitution versus National Assembly, where Lenaola J, as he then was, expressed that the basic structure of the Constitution, which is commonly known as the architecture and design of the Constitution, ensures that the Constitution possesses an internal consistency deriving from certain unalterable constitutional values and principles, and that where the basic structure of the design and architecture of our Constitution is under threat, this court can genuinely intervene and protect the Constitution. In short, the doctrine of basic structure and the pillars on which it is founded has been recognized and applied by our courts and is very much part of our jurisprudence. It is not as alien a concept as perhaps some of the appellants argued in this case. In his book, Presidentialism in Commonwealth Africa, Professor Nabweze, in his discourse on abolition and attenuation of restrictions on the amendment power, discusses what he terms as the assault on the Independence Constitution of Kenya, which resulted in quote-unquote sweeping away of restrictions that had been entrenched with regard to alteration provisions. He states that the assault, culminating with what he refers to as the final stage, where an amendment could be made by a unicameral National Assembly with 65% majority, less than the usual two-thirds. Against that backdrop, he argues, and I quote, "A constitution is supposed to be a permanent charter, which is to endure for all ages to come, not to be lightly altered to meet the temporary expediency of party politics. If the procedure for its amendment is not sufficiently rigid, and the temptation to alter it in accordance with the fancy or interest of the party in power is succumbed to over readily, the Constitution loses its sanctity in authority of the bedrock of constitutionalism and may become instead a mockery of the very idea of a government of laws. This is not to say that a constitution should be made unduly rigid, since that might invite its overthrow by revolutionary means when a genuine need for change has risen and cannot be effected constitutionally." He goes on to say that it may even be considered that the need for a constitution that is able to evolve with changing social and political conditions is perhaps greatest in a developing country. And then says that the really fundamental aspects of a constitution should be immune from alteration without reference. The really fundamental aspects of a constitution should be immune from alteration without reference to the people. He goes on to note, to give experiences, I think, from other jurisdictions in Africa, and I therefore then conclude that there is abundant authority, therefore, based on which the High Court concluded that the doctrine of basic structure applies in Kenya. What does all this mean in the context of the Constitution and the present appeals? It is perhaps in the manner of the application of that doctrine in the context of Chapter 16 of the Constitution where my perspective somewhat differs from that of the High Court. The journey of the Constitution of Kenya 2010 is well documented in the final report of CKRC, as well as the final report of the Committee of Experts on Constitutional Review. The High Court, in this case, also gave that account. The Committee of Experts concluded in its report that, quote, "The new Constitution of Kenya is a compromise, and none of the interest groups, including the Constitution, the Committee of Experts itself, politicians and the religious sector, and the Kenyans at large got all that they wanted. But Kenyans must stand tall in the knowledge of having bestowed on themselves and future generations a constitution of their own, and one that corresponds to their will and aspirations for a better, peaceful, and prosperous future, and that what remains is to be vigilant in ensuring that the new constitution is implemented in the way in which it is designed to be. As I have already stated, the High Court in the present case found that in the making of the Constitution of Kenya 2010, Kenyans were insistent on the four sequential processes in the form of civic education, public participation and collation of views, constituent assembly debate, consultations, public discourse, and ultimately a referendum to ratify the Constitution. According to the High Court, Kenyans intended that the constitutional order they so painstakingly made would only be fundamentally altered or remade through a similarly informed and participatory process, and that it is clear that Kenyans intended that each of the four steps in the constitution making would be necessary before they denatured or replaced the social contract they bequeathed themselves in the form of Constitution of Kenya 2010. I understand the High Court to say that in making the Constitution of Kenya, Kenyans adopted a rigorous process involving the four stated steps to make it. To remake it or to fundamentally alter it, an equally rigorous process, as was used in making it, must be undertaken. In that finding, the High Court appreciated, correctly in my view, that a distinction must be made between amendment of the Constitution and abolition or annulment of the Constitution. For if what is proposed as an amendment is not in fact an amendment, then the provisions in the Constitution on amendment cannot be used to abrogate the Constitution. In his article, Constitutional Amendment and Dismemberment, Richard Albert argues, and I quote, "The impetus behind the theory of constitutional dismemberment is that some constitutional amendments are not amendments at all. They are self-conscious efforts to repudiate the essential characteristics of the Constitution and to destroy its foundations. They dismantle the basic structure of the Constitution while at the same time building a new foundation rooted in principles contrary to the old. These constitutional changes entail substantial consequences for the whole of law and society." End of quote. Abolishing or abrogating provisions of the Constitution in such a way as to alter its foundation and structure is therefore not envisaged under Chapter 16 of the Constitution. That is a preserve of the people exercising sovereign power, which belongs to them in accordance with Article 1 of the Constitution. To that extent, I am in agreement with the High Court. As I have stated, it is in the manner of the application of that doctrine, given the text of Chapter 16, where I take a different path. According to the High Court, the identification of whether a provision of Constitution is part of the basic structure is a matter of analysis on a case-to-case basis. In the words of the High Court, quote, "Whether a particular clause in the Constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution, its foundational structure, its text, its internal coherence, and the history of the clause, and the constitutional history, and other non-legal considerations permitted by our canon of constitutional interpretation principles." End of quote. On my part, I am persuaded that the framers of the Constitution identified for all to know what the basic structure of our Constitution is. In what learned counsel referred to as the hierarchy of norms, the framers set out in Article 255(1) of the Constitution what they identified to be the fundamental pillars that define the Constitution. Those provisions are amendable in the sense in which I have referred to that word as meaning minor revision, addition, or modification in contradistinction to dismemberment in accordance with Article 257. Provided the amendments proposed do not amount to an abrogation or dismemberment of the Constitution, they are permissible. But even then, such amendment not amounting to dismemberment of the matter set out in Article 255(1) of the Constitution must be done in accordance with Article 257. In other words, the doctrine of basic structure, as I understand it, is a complete bar to dismemberment or abolition of provisions of the Constitution in the name of amendment. Abolishing or abrogating those provisions cannot be an amendment within the purview of Chapter 16 of the Constitution. On the other hand, under the Constitution, all provisions of the Constitution are amendable in the sense of correcting, modifying, clarifying, improving, or expounding, without fundamentally altering the identity of the Constitution. The matrix, as I see it, is that if a proposed change to the Constitution is a dismemberment of the Constitution, then Chapter 16 provisions are not available. If, on the other hand, the proposed change is an amendment, properly so called, then the next question is whether it relates to a matter set out in Article 255(1) of the Constitution. If so, then the provisions of 257 must be invoked. If it does not touch on any matter set out in 255(1), then the amendment may be pursued via the parliamentary initiative route under 256. Ultimately, however, whether a particular proposed amendment is strictly that or a disguised attempt to abrogate the Constitution is a matter for judicial interpretation. Based on the foregoing, my conclusion in relation to the basic structure doctrine is that it is applicable in Kenya. In its application in the context of our Constitution, it bars the dismemberment, replacement, or abolition of the Constitution in the name of amendment. The Constitution does not envisage, contemplate, or permit its replacement, abrogation, or its dismemberment. That is a preserve of the people and can only be done by the people outside the framework of the Constitution, following the procedure used or akin to that used to make the Constitution, and which must include civic education, public participation, collation of views, constituent assembly debate, and ultimately a referendum. The doctrine does not, in my view, prevent genuine amendments to the Constitution. The framers of the Constitution identified the matter set out in Article 255(1) of the Constitution as the core or the basic structure of the Constitution, and any amendments properly so called to the Constitution relating to or touching on those matters can be done in accordance with Article 257, infused with the national values and principles. Whether a proposed amendment amounts to a dismemberment, abolition, or derogation of the Constitution is, as I have stated, ultimately a matter of judicial interpretation. Any other amendment to the Constitution that does not relate or touch to those matters can be made in accordance with 256. In my view, there are no eternity clauses in the Constitution. I then look at the scope of popular initiative and public participation, and I conclude as follows. Having considered the rival arguments on the remit of popular initiative and popular participation, the issues arising are whether an amendment of the Constitution by popular initiative is a preserve of the citizen, whether the President or the Executive can initiate amendments through the popular initiative, who was the promoter in this case, what is the scope of public participation in that regard. And I set out the provisions of Article 257, which I will not read. And I then say that on the face of those provisions, there is no qualification of who may or may not promote a popular initiative. As correctly submitted by counsel for the appellants, there is no explicit bar against any person, including the President, from promoting a constitutional amendment by popular initiative. It is not, as it were, in the black letter of Chapter 16 of the Constitution who may or may not propose an amendment. It is a matter of interpretation in accordance with the principles of constitutional interpretation to which reference has already been made. And then I go on and say, in the end, the framers of the Constitution separated the route which the elected representatives can take for amending the Constitution through parliamentary initiative under Article 256, and the route which the citizen can take through popular initiative under 257. Although the phrase popular initiative is not defined in the Constitution, the background I have set out above and the lexical meaning of the word popular lend credence to the conclusion reached by the High Court that the amendment by popular initiative under Article 257 is the preserve of the citizen. The concise Oxford English Dictionary, for example, the word popular is defined as including intended for or suited to the taste or means of the general public. Merriam-Webster Dictionary also defines the word popular to mean of or relating to the general public. In both definitions, the phrase general public features, and I do not think the President or the Executive would fall under the category of general public. In reaching this conclusion, I am cognizant of the provisions of Articles 19, 20, 22, 24, and 38 of the Constitution, and the contention that the holder of the office of the President, like every citizen, is entitled to enjoy rights under the Bill of Rights. However, it seems to me that the curtailment in certain respects of those rights in relation to the holder of the office of the President is sanctioned by the Constitution, given the constitutional role assigned to the holder of that office in the process. As to who the promoters with respect to the Constitution Amendment Bill is concerned, I will just summarize that and say, I take the view that the process began with a handshake, followed by the establishment by the President of the task force. Thereafter, the President established the BBI steering committee, whose mandate included proposing constitutional reforms. The BBI steering committee generated the Constitution Amendment Bill. The President and Honorable Raila Odinga then flagged off the signature collection. The Constitution Amendment Bill and the list of voters supporting was then delivered to Iebc by Honorable Mohammed and Honorable Waweru, the co-chairs of BBI National Secretariat. And I then say it is a continuous process, it is a continuum. It is unnecessary, in my view, to attempt to split that process to justify the claim that the process towards initiating the popular initiative began with the delivery of the draft amendment bill and supporting signatures to Iebc, and to ignore what preceded that. The delivery of the draft bill and supporting signatures to Iebc was part of a process that had begun before the generation of the draft amendment bill by the steering committee. In my view, all the players in that process, beginning with the President, Honorable Raila Odinga, the BBI steering committee, Honorable Mohammed, Honorable Waweru, qualify as promoters in a continuum that preceded the delivery of the bill. I do not think there is merit in the contention that the President's involvement in the amendment process was in his capacity as a private citizen. The material presented shows otherwise. The Kenya Gazette notices based on which the task force and steering committee, whose mandate, as I have mentioned, included consideration of proposals for amendment of the Constitution, are testament that the President was acting in an official capacity. And then regarding public participation, I have made reference to the guidelines that were given by the Supreme Court of Kenya in the British American tobacco case, and I have set those out. And then I have said that there can be no question, therefore, that public participation is a fundamental constitutional principle in our country, a major pillar and bedrock of our democracy and good governance, to quote the words of retired Chief Justice Musinga in the matter of the National Land Commission. It is a constitutional command that it must be infused or integrated into the amendment process under Chapter 16. And then I set out other arguments, and then I conclude that I am therefore in agreement with the High Court that there is a legal requirement under Article 10 of the Constitution for voters to be supplied with adequate information to make informed decisions. There is no evidence that that was done in this case. I would not go as far as the High Court did in prescribing in minute detail how public participation might be undertaken. As the Supreme Court stated in British American tobacco case, allegation of lack of public participation must be considered within the peculiar circumstances of each case, and the mode, degree, scope, and extent of public participation is to be determined on a case-to-case basis. It is perhaps also a matter for the legislature to prescribe in appropriate legislation the scope and breadth of public participation, short of which the court is left to apply the standard of reasonableness on a case-to-case basis. To be clear, I take the view that amendment, properly so called, of matters touching or relating to Article 255 is achievable through what the High Court referred to as secondary constituent power, namely public participation and referendum. And then I deal briefly with the issue of verification. And then I say as follows. Having considered the arguments, I take the following view. The role of IEBC upon delivery of the draft bill proposing amendment to the Constitution by popular initiative is set out in Article 257(4). In an affidavit sworn on 25th of February 2021, Michael Goa, a Director of Legal and Public Affairs of IEBC, deposed that IEBC received the draft amendment bill on 10th December 2010, accompanied by 4.4 million supporters' signatures, upon which it issued a press release on 18th December informing the public of the same. That IEBC carried out a process to confirm that the said initiative was supported by the signatures of at least 1 million registered voters in order to ensure compliance with the requirements of Article 257. That after completion of that process, an interim report was prepared during which data cleaning exercise by removing incomplete records, including missing signatures, ID numbers, names, duplicates, and those not in register, and that a list of verified supporters was uploaded on IEBC's website to enable them to check and confirm their details. That the purpose of uploading the list of verified supporters on the website was to provide an opportunity for objection by anyone who had been captured as a supporter without their consent. That upon completion of that process, it was established that the popular initiative met the constitutional threshold and the amendment bill was transmitted to the county assemblies. Based on the depositions in that affidavit, the finding by the High Court that the role of IEBC under Article 257(4) entails ascertaining the number of registered voters in support of a popular initiative to amend the Constitution and verifying that the initiative is indeed supported by the registered voters claimed to be in support is correct. As submitted by Council, the verification of signatures of supporters of the Constitutional Amendment initiatives entailed ascertainment of whether they were registered voters and had appended their signatures. The controversy appears to be with regard to precisely how IEBC was to execute or carry out the verification. According to IEBC, by posting the list of voters claimed to have supported the initiative on its website for scrutiny, with an invitation that any objections should be raised within a given period. The respondents, on the other hand, argue that IEBC should undertake a forensic examination. In the case of National Super Alliance versus IEBC, the court stated that courts cannot step in to police or prefect independent constitutional bodies or direct them how to carry out their own mandates, unless there is willful neglect or violation of their constitutional or statutory functions. And the independent commissions are clothed with discretion and latitude to decide the governance process or the procedure to employ as to how and when to execute their mandate, as long as it is within the law, and that this operational and functional independence has constitutional underpinning. So guided, the question is whether IEBC properly discharged its verification mandate under Article 257(4). The record shows that IEBC uploaded the list of signatories in support of the initiative on its website on 21st of January 2021. The closing date for scrutiny and for any objections to be taken was indicated to be Monday, 25th January. Under item Q and R of Part B on verification procedure of IEBC's administrative procedures, it states that after actual signature verification exercise and documentation, the compiled list of supporters is published in the Commission's website for information and verification for 2 weeks. Publishing the list of supporters over a weekend was clearly in violation of IEBC's own prescribed time frame of 2 weeks. The time provided for scrutiny and for raising objections was grossly insufficient. Why IEBC was in such a rush is not clear. Secondly, there is the question whether merely uploading the list on IEBC's website without more is sufficient. Would it have been more effective for IEBC to, in addition to uploading the list on its website, to publicize the matter in other media as well? These questions are germane and bolster the argument that a comprehensive legal or regulatory framework for the conduct of referendum is important. In my view, had the IEBC given sufficient notice opportunity and means to the public to interrogate the list of verified supporters of the initiative, it would perhaps have been considered to have been discharged its duty of ascertaining and verifying that the registered voters who had indicated as supporting had indeed done so. That said, the conclusion by the High Court that Iebc's role under 254 involved both ascertainment of numbers of registered voters in support of a popular initiative to amend the Constitution, as well as verification of the authenticity of those signatures, is partially correct in my view. Yes, Iebc is required to ascertain that the threshold of 1 million registered voters is met. Secondly, it must verify or establish or confirm that those voters whose names that have been submitted have in fact endorsed the initiative. That, as I have stated, is in my view achievable if Iebc affords reasonable means and opportunity for the voters to interrogate and confirm their endorsement of that initiative. That said, this discussion is further testimony of the need for legislative and regulatory framework for matters relating to Article 257. I then move on to look at the regulatory and legal framework, and I think I'll just go to the conclusion. And I say this: there is undoubtedly, therefore, some legal framework, albeit not an elaborate one, for the conduct of referendum, even though it may not specifically address or fully address all aspects of a referendum, including matters of collection, presentation, and verification under Article 257 of the Constitution. I do not doubt, as I have mentioned, that it is important to have specifically tailored legislation that specifically and fully addresses matters relating to Article 257. Indeed, there is realization in that regard, as it was demonstrated that there are 2 pending bills before the National Assembly in that regard. That said, I agree with the High Court that notwithstanding the absence of an enabling legislation as regards the conduct of a referendum, such constitutional process may still be undertaken as long as the constitutional expectations, values, and principles and objects are met, and that in doing so, the process must be in strict compliance with inter alia Article 10 of the Constitution, which prescribes the national values and principles, and that those principles must be infused at every stage of the process. That statement is consistent with the legal principle exemplified by a decision of this court in Iebc versus National Super Alliance, where this court reversed a finding by the High Court invalidating procurement of ballot papers without legislative framework to facilitate a meaningful program of public participation. In doing so, this court expressed, and I quote, "The absence of a legal framework for public participation is not an excuse for a procuring entity or a state organ to fail to undertake public participation if required by the Constitution or law. A state organ or procuring entity is expected to give effect to constitutional principles relating to public participation in a manner that satisfies the values and principles of the Constitution." End of quote. Equally, the absence of a legal framework per se cannot be a basis for asserting that Iebc should not discharge its constitutional mandate under Article 257. There is also the High Court decision in Titus Alila, where the question whether there was a proper legislative framework for holding a referendum arose, and the High Court found that the Constitution has already set up a proper legislative framework. In my view, therefore, the declaration by the High Court that the absence of a legislation or legal framework to govern the collection, presentation, verification of signatures, and other conduct of referenda renders the attempt to amend the Constitution through the Constitution of Kenya Amendment Bill flawed, even though qualified with a statement in the circumstances of this case, is one I am respectively unable to endorse. To the extent I construe it to mean that Iebc cannot, absent specific legislation on conduct of referenda, conduct referendum under Article 257. There is then the matter of Iebc's administrative procedures. And on that, I capture the arguments and then say that whereas the administrative practices were not avowedly made in exercise of the Commission's power under Section 31 of the Act, in a replying affidavit sworn by Michael Goa of Iebc, he deposed that the administrative procedures were developed pursuant to Section 55 and Regulation 98 of the Election General Regulations 2012 after extensive public participation. Accordingly, based on Michael Goa's deposition, the administrative procedures fall within the statutory definition as they are made or established in execution of a power conferred by or under an act of Parliament, under which that statutory instrument or subsidiary legislation is expressly authorized. Moreover, this court can only interfere with the decision of the High Court if it is established that the High Court misdirected itself in law and that the decision is plainly wrong. On the matter of quorum, I say this. My view is as follows. Section 5.1 of the Independent Electoral and Boundaries Commission provides that the Commission shall consist of a chairperson and 6 other members, appointed in accordance with Article 254 of the Constitution and the provisions of the Iebc Act. Section 5.3 provides that the process of replacement of a chairperson or member of the Commission shall commence at least 6 months before the lapse of the term of the chairperson or member of the Commission. Section 5.4 provides that the procedure set out in the first schedule shall apply with necessary modifications whenever there is a vacancy in the Commission. Section 7A of the Iebc Act provides that the office of the chairperson or a member of the Commission shall become vacant if the holder dies, resigns from office, or is removed under circumstances specified in Article 251 and Chapter 6 of the Constitution. Under Section 7A(2) of the Iebc Act, the President is required to publish a notice of vacancy in the Gazette within 7 days of the occurrence of such vacancy, and the process of recruitment, quote, shall commence immediately after the declaration of the vacancy by the President, end of quote. Section 8 of the Act provides that the conduct and regulation of the business and affairs of the Commission shall be as provided for in the second schedule, but subject thereto, the Commission may regulate its own procedure. Paragraph 5 to 7 of the second schedule, prior to amendments introduced through the Election Laws Amendment Act number 34 of 2017, provided, and I have reproduced those provisions there, I will not read them, and then I say that through Election Laws Amendment Act 34, paragraphs 5 and 7 of the second schedule are repealed and replaced with those provisions. Paragraph 8, which was not affected, of the second schedule, provided that subject to paragraph 5, no proceedings of the Commission shall be invalid by reason only of a vacancy among the members thereof. Those amendments were successfully challenged and declared unconstitutional by the High Court in Katiba Institute case, and I have cited passages from the judgment of Justice Mwita, which are there. Iebc contends that as paragraphs 5 and 7 as previously enacted had been repealed, the declaration by the High Court invalidating the amendments did not revive the repealed provisions. It was urged that by relying on provisions of paragraphs 5 and 7 of the second schedule as they existed prior to the amending provisions being declared unconstitutional, the court relied on non-existent provisions, and therefore Article 250, which sets the minimum at 3, applied. Respectfully, I do not understand the decision of the Supreme Court in the case of Mary Wambui, which was cited as supporting the proposition put forth by Iebc. If I understand the argument correctly, it is that the effect of the declaration of unconstitutionality by the High Court of the provisions of the Election Laws Amendment Act number 34 that had sought to amend paragraphs 5 and 7 of the schedule is that the schedule is now silent on quorum. That there is in effect no longer a provision at all in the schedule on quorum, and therefore recourse must be had to Article 250. I am not entirely persuaded by that argument. Article 250 of the Constitution does not, with respect, address the question of quorum of the Commission. It is a provision on composition. It sets the minimum number of persons who must make up the Commission. Quorum speaks to the minimum number of commissioners that must be present to make a binding decision. It speaks to the number of commissioners who, when duly assembled, are legally competent to transact the business of the commission. As defined in Black's Law Dictionary, it is the minimum number of members who must be present for a deliberative assembly to legally transact business. Article 250 of the Constitution cannot therefore fill the gap which the Iebc says was created by the declaration of unconstitutionality of the provisions that had sought to amend paragraphs 5 and 7 of the second schedule. In the case of Mary Wambui, the Supreme Court in paragraph 87 of the judgment expressed as follows: however, while we have pronounced ourselves on the issue of invalidity of section 76(1) of the election Constitution, this court is not precluded from considering the application of the principles of retroactivity or proactivity on a case-to-case basis. I then by Justice Kriegler in the South African case of Sias Moyes, and I then go on to say that the decision of the High Court in the case of Katiba Institute was silent on the effective date of the declaration of unconstitutionality. Based on the decision of the Supreme Court, I take the view that the default position is that the declaration of unconstitutionality related back to when the unconstitutional provisions were enacted, with the result, in my respective view, that the status quo ante was restored. Therefore, the requirement of quorum of 5 applies. I am therefore in agreement with the High Court that when it pronounced in the judgment that Iebc Act categorically places the quorum of Iebc for purposes of transacting business at 5 commissioners, and that Iebc did not have that quorum at the time it made the consequential decision related to the Constitution of Kenya Amendment Bill. Iebc also contended that the impugned decision of the High Court runs afoul of a subsisting decision in rem in a constitutional matter, in the case of Isaiah B. Watt, which has been extensively cited. And I'll cut through and just say, I am conscious that this court is not presently sitting on appeal from the judgment of Isaiah B. Watt. However, it seems to me that quite apart from reading into the text of paragraph 5 of the schedule, the words policy decisions, and apart from mixing up composition with quorum, the learned judge appears to have either overlooked or infused statutory provisions with what she considered to be common sense when she stated, quote, "My take is that the issue of quorum, apart from being a matter provided for under the statute, is also a matter of common sense and construction, depending on the total number of commissioners." And then I have the rest of the passage, and then I say, further, in making that pronouncement, the learned judge does not appear to have considered the provisions of paragraph 8 of the second schedule, which provides, subject to paragraph 5, no proceedings of the commission shall be invalid by reason only of a vacancy among the members thereof. Under that provision, the requirement under paragraph 5 is overriding. The pronouncement by the judge in the above cited passage appears, therefore, to be an abrogation of a statutory provision, and to that extent is per incuriam. Consequently, the High Court in the present case was entitled, for that reason, among other reasons the court gave, to depart from it. Moreover, the statutory commands in the Iebc Act, if heeded and complied with, would have ensured that the number of commissioners would not have fallen below the number required to form a quorum. For those reasons, the complaint regarding the findings by the High Court as to quorum have no merit. I then move on to the issue of continuous voter registration, and I think I'll just say what I concluded. The High Court cannot therefore be faulted for having concluded, as it did, that there was no evidence that Iebc had discharged its obligation of continuous voter registration. I would therefore not interfere with the decision of the High Court. The last aspect I think I'll look at, separate and distinct referendum questions. On that I say, in my reading of those provisions, that is of the Constitution, it is the bill in which an amendment proposal is contained that is submitted to the people to vote on in the referendum by indicating whether they agree or disagree with the amendment proposal, much in the same way as the members of the county assemblies and members of the houses of parliament would have signified their approval or disapproval of the amendment process in the draft bill. It seems to me, therefore, that under Article 257.10 of the Constitution, as read with other provisions in that article, what is envisaged of the voter at the referendum is for the voter to make a choice to ratify or not to ratify, to approve or not to approve the amendment proposal in the draft bill. However, that choice, in my view, is rendered nugatory, inoperative, and consequential if the voter is called upon to vote on an omnibus draft bill that contains a raft of numerous, diverse, and unrelated proposed amendments to the Constitution, in this case over 70 proposals, that cut across the entire spectrum of the Constitution. And I cite the passage there from the High Court decision entitled Alila. The argument made for the respondents on the principle of unity of content or single subject matter, that constitutional amendment through a referendum should deal only with one main issue, is one I find most attractive and persuasive. It was argued that under that principle, the proposed amendment should deal with one subject only to allow the voter to form and express their opinion freely and genuinely. In other words, if a proposed constitutional amendment includes several substantive questions, the voter may not have a free choice, that each proposed constitutional amendment ought to secure adoption on its own merits, not on the merits of other different proposals to which it is attached, and that there must be an intrinsic connection between the various parts of each question to put to the vote in order to guarantee freedom of suffrage, and the voter must not be expected to accept or reject as a whole provisions without an intrinsic link between them. I would venture to suggest that what is envisaged under Article 257 is an amendment bill on single thematic topic to which the provisions in the draft bill must relate. For instance, a bill proposing amendments to the provisions on land under Part 1 of the Chapter 5 of the Constitution would, in my view, be incongruous with proposals in the same bill for amendment of the unrelated matters of the Office of Parliament under Part 3 of Chapter 8 of the Constitution. Ultimately, it seems to me that to put a single binary question or multiple questions is a matter to be informed by the nature of the amendment proposed. It may well be that certain proposed amendments may require separate and distinct referendum questions to be framed. What, in my view, Article 257.10 of the Constitution does not contemplate is the submission to the people in a referendum of an omnibus amendment bill, a hodgepodge of an amendment bill such as the Constitution Amendment Bill in this case. The argument that it would be impractical on account of logistical difficulties to formulate over 70 separate and distinct questions is perhaps more the reason that an omnibus amendment bill should never be entertained. Then I move on to constituency apportionment, and I think I have agreed with the lead judgment of the President, and so I will not deal with that. And then I deal with the matters touching on the President. Under this head, the issues are whether the President's right to fair hearing was violated, whether the President enjoys absolute immunity under the Constitution, whether the High Court was right in declaring that the occupier of the office of the President is liable to being sued in his personal capacity during his tenure of office. And I think I'll just go to the conclusions, which are as follows. Article 51 of the Constitution provides that every person has the right to have any dispute that can be resolved by application of law, decided in a fair and public hearing before a court, or if appropriate, another independent and impartial tribunal. Therein is the long-standing principle of natural justice that traces back to Ridge versus Baldwin, and also the case of Onyango, Olo Onyango versus Attorney General. I have also cited it there. The critical question, which is a matter of fact, is whether the President was firstly served with a petition 426 in which he was named as the first respondent, and secondly, whether he was served with notice of hearing. The record of proceedings of 21st of January 2021 show that the High Court gave directions on the conduct of the consolidated petitions. Among the directions given on 21st were directions that, quote, all the petitioners in the 7 petitions to serve the petitions on all the parties by close of business on 22nd of January 2021. The Deputy Registrar to facilitate the process where necessary, and that the respondents, interested parties, and amici to file and serve their responses to the various petitions within 14 days. On the same date, directions were given by the court regarding exchange of written submissions and the conduct of the hearing and hearing dates. The record shows that on subsequent appearances before the High Court, under the quorum in relation to petition 426 of 2020, the court always indicated no appearance for first respondent. The record does not show whether after the directions given on 22nd January 2021, any inquiry or follow-up was made by the court to confirm that its directions regarding service had been complied with. In subsequent attendances before the High Court, the record continued to reflect that there was no appearance for the first respondent, that is the President, in petition 426. The petitioner in 426, Isaac Aluocher, indicated on the face of the petition that it was to be served at the office of the President, Harambee House, Harambee Avenue, Nairobi. An email address was given and telephone numbers and a Twitter handle. Before this court, Mr. Aluocher filed a supplementary affidavit dated 8th June 2021 in which he attached an affidavit of service sworn on 16th of January 2021, in which he stated that he served the petition by email on all the parties, including the President, whom he served at the stated email address on 21st of December. He stated further that he also lodged a service request with the judiciary e-filing platform and got a response on 15th January, and that all parties had been served. Notwithstanding the directions given by the High Court on 21st of January, to which I have referred, it appears to me that the question whether the President was in fact served with a petition and the hearing notice in respect of the hearing appears to have been overlooked by the High Court. The continued indication in the record, no appearance for first respondent against the name of the President, after the directions given on 21st of January, should respectfully have signaled the court to inquire whether the President had in fact been served. The depositions by Mr. Aluocher in his affidavit sworn on 16th January 2021, filed in hearing, are matters that should have been presented before the High Court in order to satisfy itself that the President was duly served. In paragraph 537 of the judgment, the High Court observes that the President did not enter appearance in these proceedings, and neither did he file any grounds of objection or replying affidavit to contest these proceedings on the ground of misjoinder or any other ground. However, there is no indication that the High Court satisfied itself that service had been effected in the first place. Indeed, in the same paragraph of the High Court judgment, the court stated, quote, as much as the Honorable Attorney General has come to his defense, the grounds of objection and submissions filed by the Honorable Attorney General are clearly stated to have been filed on behalf of the Attorney General himself and not for Mr. Uhuru Muigai Kenyatta, end of quote. An acknowledgement, in my view, that the proceedings against the President were undefended. Having concluded that the Attorney General could not in this instance represent the President, it was imperative for the court to satisfy itself that the President had been served with the petition and the hearing notice. It is also noteworthy that although the High Court expressed in paragraph 532 of its judgment that the question whether the President can be sued in his personal capacity and not as the President of the Republic, that, quote, should be determined as a preliminary issue, quote, it was not in fact handled in that manner. For had it been handled in such manner, the determination should have been made before the substantive hearing of the petition commenced to afford the President an opportunity to defend himself in his personal capacity. By making the determination in the final judgment, that opportunity was lost. All in all, I am not persuaded that it was satisfactorily demonstrated that service on the President was effected, and for that reason alone, I would set aside the orders made by the High Court against the President in Petition 426 of 2020. On the presidential immunity question, I have indicated that I sat in the judgment of this court in Kenya Human Rights Commission and another versus Attorney General, and my views have not changed that the decision of the High Court is right in that regard. I still hold, therefore, and agree with the pronouncement by the High Court in the present case that the President can be sued in his personal capacity during his tenure because the protection afforded under Article 143(3) of the Constitution extends, quote, anything done or not done in the exercise of his power under the Constitution. On the issue of the amicus curiae, I have referred to the Supreme Court decision of Trusted Society of Human Rights and the extensive guidelines that were given there, and I have concluded that it was not demonstrated that the High Court exercised its discretion wrongly in admitting the amici. On the issue of justiciability, I have said that the matter was ripe and that it was not prudent for anybody to wait until the provisions became the Constitution and then have to contend with Article 2(3) of the Constitution, which prohibits any challenges to the Constitution. So with that, I will end it there and hand it over back to the President. Thank you.
Thank you very much, my brother Justice Gatembu. It is now 1:40. We shall adjourn for 1 hour. And so we will be back at 2:40. The court will adjourn.